Hi, everybody. Welcome to the second West Slope Startup Week. We have over 70 sessions every Tuesday and Thursday in July, so this is the last week. Thank you for tuning in. They are all crafted by members of our entrepreneurial community in Colorado and on the Western Slope, so we're really excited to have you guys. It was created with the intention of just bringing people together, allowing them to share ideas and learn from one another. Before we get started, just some housekeeping. We ask all the participants to have their camera on if they would like and mute on as well, unless there's a question or you guys are having a conversation. And we would also like to thank all of our sponsors, especially US Bank, for making this possible. And with that, I will turn it over to David.
All right. We had a question real quick about if this is going to be able to be downloaded later, I believe, is what the question was.
Yes, it will. It'll be on the sketch where they found this session. It'll just be placed in a link there.
Sounds good. Are we able to see my presentation? No?
No.
Okay, let me share it again real quick.
All right, looks good.
All right, good deal. Hi, everybody. My name is David Lay. I am the Assistant Regional Director at the Rocky Mountain USPTO down in Denver. I've been with the agency for 11 and a half years and took on the role of Assistant Director in February. So right before all this madness decided to start. My co-presenter is Ryan Anderson. Ryan, do you want to introduce yourself?
Sure, thanks, David. I'm Ryan Anderson. I'm a patent attorney, trademark attorney here on the Western Slope of Colorado with the law firm of Larson and Anderson. We do patents, trademarks, intellectual property, mainly on the prosecution and procurement side. I am out of the office at Great Grandma's house in Minnesota, taking care of some business this week. So I'm out of Colorado, but looking forward to giving the presentation with David here.
Good deal. And both of us did this presentation last year. And so we should be able to familiarize ourselves with this once again and hopefully help everybody out. Just a little disclaimer about the pictures and images that are being used. They're purely for educational purposes. Since we're the government, we just wanted to put that on there. But what is intellectual property? The session is called Fundamentals of IP. IP stands for intellectual property. On the left, you see real property there. It's a house, it's land, it's defined by, or it's contained by a fence line. So just as a fence line kind of dictates what you own in terms of your own property, intellectual property can be owned as well. It's the ownership of a concept, of an idea, rather than something tangible or a piece of a parcel of property there. Ownership of IP allows the owner to exclude and other people from using the idea or concepts with the intellectual property at issue. These are the four major types of intellectual property: a patent, a trademark, copyright, and a trade secret. Patents are what most people associate with a widget, some kind of gadget that is a little physical thing, a computer, camera, cell phones. Those are most people associate with patents there. A trademark is wording or branding, things that identify a business to the consumer. This helps the consumer because it protects them from counterfeits or knockoffs of other people's infringing trademarks. So if you see big golden arch, usually you'll associate that with McDonald's. That helps you, for good or for bad, identify that food is coming from a source that you know. Copyrights usually protect forms of expression, art, software code, music, things that you write yourself, recipes even. And those are while they're difficult to create initially, they usually require some kind of artistic talent. They're really easy to copy, and they're major source of a lot of the internet infringement that occurs, downloading music, stuff like that, Napster back in the day, and always a big topic for most people. And then finally, trade secrets. Trade secrets are a type of intellectual property that is often kept secret. Otherwise, it wouldn't be useful anymore. The two examples there are the Coca-Cola formula and KFC's, the Colonel's secret recipe. Those are things that have never been revealed. And I think it was Coke that only has 2 people alive that know the recipe for that. And so that's been able to carry on their company for a very, very long time. Why is IP important? This is the reason why most people are here in these sessions, to kind of learn about what advantages you have over your competitors, over other companies, and just in general, how this can help you get funding for the future. There's statistics that I think Ryan will touch on later on, that the bright side of patents, it's a paper that the USPTO chief economist wrote a few years back, kind of shows the importance of how you obtain funding while because of your IP portfolio, whether it be trademarks and patents. Those are the things that increase your ability to obtain venture capitalist funding, second round funding, IPOs, and sales growth in general. Here's an example of all the different types of IP that are in a phone. A lot of this I mentioned previously. The trademarks, the little logo of the Apple on the back of the iPhone, usually the iPhone itself, iOS is branded. And so whenever you have those types of markings there, that's associated with the Apple iPhone. The copyright that's associated with it is the software code that's used to power the phone, the instruction manuals and the ringtones, the art, the icons, those are all graphically there. You can distinguish those usually from other phone providers and other phone companies, whether it be Nokia or Samsung or whatnot. The patents associated, as you can see, processing mechanisms, the microphones, probably even those buttons, the cameras, everything that's associated with kind of the hardware side of that, those are usually in the utility patents. And then design patents, that's the overall shape of the phone. Apparently the layout of this and the bezel are included as design patents. We'll distinguish a little bit between design patents and trademarks here in a little bit. And then trade secrets, obviously, if we knew what those were in the phone, then they wouldn't be secret anymore. So there might be some associated trade secrets with the phone as well. Trade secrets real quick. So as I mentioned earlier, the secret recipe, Google has a trade secret actually on their search algorithm. That's been developed and protected to utilize their search algorithm. That's why so many people use the search engine of Google. That's a big thing for them because that's one of those things that they never decided to patent themselves. They wanted to keep that a secret so they can continue to utilize their secret to operate their company. The ways to lose trade secrets are just kind of telling anybody. If you go and tell anybody and that gets distributed amongst competitors, or someone decides to come up with the secret recipe from Colonel Sanders was out there and you decided that you could taste it and pick apart all the spices that are in it, then that would be one of those ways that you would lose the trade secret. Someone decided to come up with the same exact way to do the search algorithm for Google. That'd be what's considered independent development. It's doing the same thing that Google is doing, but they developed themselves and they did all the research and coding of their own method to find that out. And like I said, kind of disclosing it yourself or just telling anybody, that's usually the first way you lose it, is by telling other people.
David, can I jump in there real quick on the trade secret? So I think the key for trade secret is that it's a secret. There has to be active steps to keep it a secret. Active steps could be anything from having just a written down protocol of how you handle your trade secret, employment agreements saying when you leave the company, you can't talk about this if you know it, only sharing the information with those people that need to know it. All those things are active steps that are important to record for having a trade secret. And of course, when it's no longer secret, then you have lost your trade secret. I guess also, if anyone has any questions, feel free to jot them down in the chat, and hopefully we can get to them during the presentation and talk about them when it makes sense. Otherwise, if we have time at the end, we'll see if we have some time to open it up if anyone wants to unmute and talk during the presentation. So carry on, David.
Awesome. That reminded me a couple of other things about trade secrets as well. This trade secret stemmed from common law in the 1800s. Traditionally, it had never had a way to protect itself, for you to protect yourself if your trade secrets were kind of exposed. In 2016, they had the Defend Trade Secrets Act that allowed the owner of trade secrets to sue in federal court when misappropriated. And so that's kind of been a turn. I'm not familiar with any major cases that's resulted from that, but at least now there's a remedy for misappropriation of your trade secrets there. All right, now we'll go into copyright. As I mentioned earlier, these are examples of items that can be registered for copyrights. The Library of Congress actually handles the copyright registrations, while the USPTO handles patents and trademarks. There's a little sound icon. If this was, I don't have PowerPoint on my computer, so if that was on the presentation, there'd be a sound there. You can hear an audio recording, and those are things, that's one of the other examples that's being protected as well. But literary works, musical works, dramatic works, pictures, graphics, sculptures, movies, sound recordings, even architectural works are all protected by copyright. Websites as well. I know now that we're 2020, everybody has a website if they're trying to sell something. So that's one of those things that you might want to consider in terms of protection there. Like I said, Library of Congress takes care of this. The term is interesting. This is the longest, no, sorry, trademarks is actually the longest, but in terms of how long you have protection for, if you register the trademark, you have until the end of the author's life plus 70 years. I think it was last year, possibly, that Disney, Steamboat Willie was finally released into the public domain. I forgot when it was. It was pretty recent that was released from Disney's control because of the 70 years past his death there. If you want to go register a copyright, you can go to copyright.gov. The fees are very minimal for a copyright there. As you can see, if you have just a work for a single person, it's $35. That's very minimal in terms of protection. A lot of people can usually associate copyright sometimes with the poor man's copyright, where you address your letter, your book, whatever it is, and mail it to yourself. That has some fallbacks, and while you do technically have a copyright, It doesn't provide for the federal registration there and the protection that the Library of Congress would afford you there. If you want to learn more about copyright, you can go check our events at uspto.gov/Denver and look for the next set of copyright seminars, essentially. We have a bunch of virtual classes over the last few months that have touched on, trying to obtain a patent or a trademark and also copyright as well. So, or you can talk to Ryan about some of the stuff.
Well, so one thing I wanted to point out is as soon as you affix something, a work of art or whatever it is, in what they call a fixed tangible medium, you're considered to have copyright in that work. What David's talking about here is the actual federal registration of that copyright, and it provides a whole basket of goods. One of the most important, I think, is probably the statutory damages that you get per infringement of that copyright. The last time I had checked, the statutory damages were $20,000 per occurrence. So you imagine if someone ran off a whole sheet or a whole ream of paper copying an artistic work, how those damages could accrue pretty rapidly.
Definitely. All right, now we'll move on to trademarks. Trademarks are kind of the gateway drug, as my director likes to call it, of IP. Most people associate trademarks because they see that in their everyday life, whether you go shopping for clothing, for food, everybody associates the branding, the slogans with certain items that they interact with in their daily life. Trademarks include, symbols, pictures, words, phrases, slogans, and as I mentioned earlier, just kind of, different things like sounds might be triggering, and anything else that can identify the source of a product from other companies. Registering your trademark is one of those things that is kind of tricky in terms of why do it. If you're using a logo and branding and slogan in your little area, your state, possibly, and everybody associates your branding with your company, that's great. If somebody else in Maine is doing the same thing, maybe possibly related to whatever you're doing with your business, and they only keep it there, then that could be also great. The problem becomes whenever you have conflicting companies that decide to register federally, and while you have been operating for 50 years or 100 years with your family doing the same business for that time, the federal registration allows them to have that identifier through all the states. This is what we refer to as common law trademarks. That's why when you see a TM, which stands for trademark, or SM, which is service mark, those are not federal registrations. Those are registrations that are common law trademarks and possibly just state registrations for your trademark. When we go to file for the federal registration, it's a $225 fee. It's all electronic filing now. I think this was initiated last fall, maybe 2 years ago. But the fees are not that extensive compared to what they could be in terms of the money that it costs to protect your brand, your company, whenever it goes to court or something like that. So federal registration allows you to protect your service, your products, whatever you want to kind of identify as your company's items there. Federal registration advantages, as I mentioned, kind of puts everybody on notice that you have that. It goes into a giant catalog. our office has a giant database of all the patents and all the trademarks that have been registered in the US. With a trademark registration, it's good as long as you maintain the use of it. There's been kind of a shift over the last decade, I guess, in terms of using trademarks. One of the more recent trademark instances was the gentleman that registered a bunch of alternate names for the Washington Redskins. 5 years ago, I believe, he decided to register as many names that might have been possible for the Redskins to change to. This was going to be his 5th year where he had to prove that he was using that in commerce. And he said that he was going to just let those default and then let those go back to the public domain, essentially. Whatever he was trying to do in terms of having those names and negotiating with the team, I'm not sure about, but there was an interview that he said that he was willing to just give the name to the team for free if it was choosing one of the names that he had registered. He had a long list of them, and he would have to maintain those fees to keep those active. I think to show that he was using those marks, initially when he got those registrations, he decided to print off a bunch of coffee mugs or items like that to show that I do produce items that use these names. And that was kind of his little way around the proof of use there. Ultimately, I think he's still planning to get rid of all those, except for maybe the ones that he's handing over to the team. But that's one of those things that are more recent that most people will kind of associate with trademarks and the registration. Ryan, did you have something there?
Well, I just add the Redskins have changed their name, so I don't know if that's going to be even relevant anymore.
Right.
But let's see. I think you covered everything. You get to only when you have the federal registration can you use the R in the circle. The TM and SM can only be used if you do not have the federal registration. And then the next slide is the likelihood of confusion slide. And so when you think about trademark and the purpose of trademark and trademark registration, the theory behind trademark is that it protects the consumer. Even though the owner or the registrant of the trademark is the owner and has the rights to that mark, the theory behind it is, hey, this protects the consumer so that the consumer knows who they're dealing with. If the consumer, so from a registration and an application point of view, the examiner will search the trademark databases and the internet and look for similar marks that may have similar goods or services that maybe there's a likelihood of confusion. If there's a likelihood of confusion of your mark and the other person's mark, you'll get a likelihood of confusion rejection in the application process. And you could deal with that and argue against that. Also in the infringement and enforcement point of view, the standard for infringement is also likelihood of consumer confusion. So is it more likely than not that a consumer would be confused by your use of the mark compared to the earlier use of the mark or the registrant's use of the mark? If the answer is yes, and there's a whole body of case law about what is likelihood of confusion. If the answer is yes, then either you can't get the registration or you'd be found to infringe, or someone could legally ask you to stop using using the mark in the way that you're using it. So that's all I had.
Good deal. And I think that pretty much covers the likelihood of confusion there. A good example of that whenever I was going through law school was learning about taco restaurants, whenever you have similar appearance inside, similar products, but you don't exactly have a Taco Bell name, but it looks the same, people might be confused as to where they're getting the tacos, where they're getting their food from. And even though, I mean, it might have its own name, its own branding, but when the feel is similar inside, whenever everything looks, close enough where people can be confused, that's where trademarks come in and protect the companies and also the consumers. If the B restaurant that is terrible gives you food poisoning and you decide to go sue Taco Bell, that's not necessarily going to work because that's not who caused the harm there. And so having distinct trademarks, service marks allows benefit for both the consumer and the company there. We'll kind of talk about the strength of the mark of trademarks real quick. This is a little bit in depth. So this is kind of the scale as to how you can obtain a trademark, or how you don't obtain a trademark, I guess. If you have a generic name like Burrito Place, that's probably going to fail to get a trademark. There's interesting court cases, one recently of Booking.com, whether that was generic or not, in terms of the booking, and then the .com, whether it adds enough there to identify Booking.com as its own service provider. I think ultimately the Supreme Court decided that it was enough, and so generic .com registrations are supposedly going to go up, but that took precedence from a few other trademark filings that I can't even remember which ones they based it off of originally, but it allowed Booking.com. Everybody, well, not everybody, a lot of people know Booking.com as, the planes, the hotels, and so that made it easy for people to understand that. But that could become a problem. Ryan?
Oh, I was just going to add, and I didn't talk to you about this, David, but the law firm that I worked at before the current one had patents.com as a trademark application that went through to the federal circuit, being registered, denied as being descriptive or generic. So that was actually one of the big court cases that's cited as descriptive. So it's interesting about Booking.com being, oh, that's different for some reason. But right. Anyway, so what we're trying to show here is that the stronger the mark is, the more fanciful and arbitrary made up word. The weaker the mark is a generic descriptive word, or something that describes or is generic of the goods and services. So the strong marks, the ones that are likely to be registered, are the fanciful, arbitrary, made up words, or even the suggestive words, merely descriptive and generic. Don't cut it in front of the trademark office.
And a good example that my director usually uses is burrito places that we're mostly familiar with. Chipotle and Qdoba. While Chipotle is a pepper, it can, invoke the feeling of Mexican food, possibly just because of the spice in the pepper. That could be considered suggestive, whether Chipotle is normally used for burritos or, indicates a burrito to you. Previously, it might never have. And so that could be that could be on the side of suggestive. Whereas there's a restaurant called Qdoba. Qdoba means absolutely nothing. That was a made up word that they decided to come up with. That was a stronger mark because it's a restaurant with the made up word, and that's more considered fanciful or arbitrary up there. And so that creates a stronger mark there. And it differentiates itself as a burrito place from all the other burrito places because of the word mark there. We'll go on to some traditional marks now. These are all examples of trademarks that Coca-Cola has. You can see just the words Coca-Cola, the logos, the bear, the little scripts, Coca-Cola red right there. And those are all different forms of their trademarks. Here's some non-traditional trademarks. These are colors. The left box, the Tiffany blue, that's a very iconic. People see that color and it invokes the thought of Tiffany's. UPS brown, whenever you see that big brown truck pull up, you expect your delivery for your packages there. And similarly, John Deere green. Other non-traditional marks are smells. These are very interesting because I would have never associated smells with a trademark. However, that first item there, it's an exhaust or an engine lubricant that made your exhaust smell like grapes. That's pretty distinct because other than diesel, I can't really tell the smell of exhaust that are different. And so that's one of those things that identified that product from that manufacturer. Verizon stores also have a trademarked smell. It is described as a flowery musk scent. I have not ever been in a Verizon store, so I'm not really sure what that smells like. But if it smells like flowers and musk, then there you go. And then finally, Play-Doh has the, quote, scent of sweet, slightly musky vanilla fragrance with slight overtones of cherry combined with the smell of salted wheat-based dough. That is the description for their trademark for their smell on their dough. I apologize because once again, I can't click on these sounds, but when you hear the giggle of the Pillsbury Doughboy, that invokes the thought of biscuits or the Pillsbury brand in general. The second one would have been NBC chimes. Once you hear the xylophone, I think it's a xylophone, it makes you think of the NBC and the peacock there, which the peacock is also their trademark, but the sound is what we're talking about here. And then the final one would have been the sound of Mario hitting the box and getting a coin. When you hear that sound, most people associate that with Mario and Nintendo. Trade dress is a very interesting form of trademark. It identifies the look of an item as to how that relates to the product and the company there. These are all iconic trade dresses there, Docs, the Hershey Kisses, the Coke bottle, and even the layout of a store as the Apple store is laid out can be trade dress. I'm going to take a second real quick to overlap with design patents because patents will be coming up right after the slide. But design patents also cover the look of an item and nothing functional. So while that shape of the Coke bottle could have had or could have started life at some point with the design patent, at some point that item became so iconic that Coke decided to register that for trade dress and trademark protection. There's advantages to doing that because design patents only last for 17 years, I believe, while trademarks can last perpetually, like as I mentioned earlier, as long as you show that you are using it. Some local Colorado examples of this are the Kong dog toys and pop sockets. And so everybody or if you have a dog and you have the little Kong, you kind of know the little snowman shape there, and that's become associated with the Kong brand. And then pop sockets, I mean, those are everywhere now, and whether you're using one or not, you see people have them on the back of their phones, and that's kind of associated with their branding. Starting off, most people don't have the trade dress of these items, the trademarks for these items, because they don't identify the brand initially. That takes some time, and so that's why most people start off with design patents there and decide to go with a design patent. And once it attains a secondary meaning, then they'll file for a trademark for the trade dress of that particular item. And now we'll go into US patents, and Ryan will have a brief overview of that for you.
Sure. Before we get there, I just had two examples of, I don't know if anyone could see this. This is a federally registered trademark that is a ribboned, stamped, sealed copy that the USPTO sends to you once you have met all of their requirements. So that's a trademark. It's actually, this is an old one. There's actually new ones now that are much prettier and colorful. Here is a granted ribbon stamped copy of a patent. The patent has all the disclosure figures, whatnot in it. And at the back of it, there's a list of claims which outline the scope of protection as defined in the ribbon copy of the patent. This ribbon granted patent from the United States Patent and Trademark Office is more or less an agreement between the inventor or the applicant with the US government, where the US government gives the applicant an exclusive monopoly to exclude others from making, using, and selling their invention as defined in the claims of the application or the granted patent. So it gives you 20 years from filing the application of exclusivity. And the trade-off is that you have to teach the world, not just the United States, but the world, how to make, use, and sell, or excuse me, how to make, and the best way you know to make and use the invention. So it's a trade-off of a public benefit to increase the public knowledge, but it gives you this exclusivity of being able to exclude others from making, using, selling, and importing the invention into the United States. I think we can go to the next slide, David.
One thing real quick.
Yeah.
And in exchange for you revealing this to the public, you get a limited term of 20 years from the time your patent is filed. And so for 20 years, you have that exclusive right and that exclusive monopoly for disclosing this to the public.
There's a couple of misnomers here about, hey, do I really need a patent? Some things I've heard or we've heard is if I just publish it, I can prevent other people from getting a patent on my invention. To a certain extent, that's true. In the US, we had a change of law fairly recently where that's no longer necessarily true. In the United States, someone else could still patent that invention if they came up with it on their own, and they could prove that without knowing about your publication. But the rest of the world, that's largely true because the rest of the world requires what's called absolute novelty for getting a patent application, which means that you have to have a patent application on file before any public disclosure. So if you publicly disclose, that sure puts a big roadblock into the path, but still, if you don't have a patent, you still can't exclude anyone else from making, using, and selling the invention. That's only when you get the registered patent. Let's see. There was another misnomer back there. I'll go back one, David. Yeah, so that's covered. There was something funny. You mentioned a poor man's trademark. I've also heard of a poor man's patent where people say, hey, I can mail myself in the US mail a full disclosure of my invention to myself, and that's going to give me some type of rights in the invention. That's not true. It might be able to help prove a date of earlier conception if you need to, for example, to satisfy a new provision under the law, but it does not give you any rights. So why get a patent? Next slide. So the reasoning rationale is usually to gain entry into the market, exclude others. You could use it for marketing purposes, or you can license it to others, license the invention. Really, all of these boil back to the ability, bullet point 2 here, of being able to exclude others. Again, the rights are exclude others once you get the granted patent, and everything else falls in from there.
Ryan, I got a scenario for you. Ultimately, people want, to get a patent for money, right? So what does patent pending mean, and how is that useful to a person that's using that term?
So patent pending is exactly what it means, that you have an application on file with the Patent and Trademark Office, the USPTO, and you can mark your product marketing literature with the term patent pending. You can't call it patented. That would be considered false marking, but you can say it's patent pending. And oftentimes, clients and people use that as a way to ward people off from trying to enter the market, or to keep them away from the invention as long as possible. We see that a lot, where people will have some type of application pending before the Patent and Trademark Office for as long as they can, so that they can mark their product patent pending. Even if they really have no hope of getting a patent on it, they could mark it patent pending for 50 years and keep filing applications and call it patent pending. It is pretty scary to see those words, but nonetheless, that's what patent pending means.
Awesome.
Let's see, why get a patent? So the next 2 slides give some pretty cool statistics about the benefits of having a granted patent. Here we see an increase in employment, sales growth, increase of probability of venture capital funding. The next, another increase in second round funding, not so much an increase of the seed round funding, which I think is kind of a misnomer. And also, I think it's a misnomer, because usually the seed round funding of a company will go to trying to file the patent application and get the patent application on file with the Patent and Trademark Office. Let's see, increase in IPO and increase of going public and etc. So it can create enormous value to a company to have the ability, like I said, that basket of rights to exclude others from doing what you're doing, and it can corner the market for yourself. So,
all right, we have a question. Can we talk about the U.S. versus other country patents, and do we need to file beyond the U.S.? Also, advice on patent searches as part of the filing process. If you want to talk about the US versus other countries, I'll talk about the searches.
Sure. So when you receive a registered US patent, that gives you the ability to that basket of goods solely within the zone of the United States. It doesn't give you any rights outside of the United States. For the rights outside of the United States, you would be looking at filing in each and every jurisdiction that you are looking forward to patenting in. And those jurisdictions typically include where you're looking at selling your products, services, where you're looking at manufacturing, we tend to have a spider rule at our office, where we don't file in countries where there's spiders larger than our hand. So that includes the US and the major European Union, Australia, China, Japan, Korea, all over. And there's certain jurisdictional agreements in unions. The European Union, UK is exiting here at the end of the year, but you can file in one-stop shops. There's also some in Eastern Europe and in Africa, of groups of nations where you could take advantage of. One also big one is the Patent Cooperation Treaty. That's kind of a one-stop placeholder for filing your international applications within a year of your priority. That's kind of getting into the weeds of how to do it, but nonetheless, searching. Go ahead, David.
Yeah, and one additional note for that. So if you file for a U.S. patent, you only get protection in the U.S. And so the benefit of filing in all those other places, as Ryan mentioned, is if you're trying to do business or make the products or doing whatever, all those items that Ryan had mentioned, then it'd be beneficial for you to file in all those other locations as well. This is a little bit more difficult if you are an independent inventor or a small business with limited funds. And that's why people like Ryan and other patent attorneys have the experience to do this. That's why they are utilized, because it's one of those things that is more beneficial for you in the long run, and they have the knowledge, excuse me, to do all that. With regards to searching, in normal times, not 2020, there are a bunch of locations that you can go to. We'll go through some of them at the very end, but in the Grand Junction area, we have a Patent and Trademark Resource Center at the library over there. That uses the same database as what examiners use on a daily basis to search for patents. If you're just trying to look for simple things that might be related to what you're working on, Google's a good start. They had all of our patent applications up there and all of our patents that have been granted up on their database as well. Our regional office in Denver, if you're closer to there, then it also has 4 search terminals that you can use with the same thing as the PTRC. We have patent and trademark resource centers all across the country that allow you to search for trademarks, that allow you to search for patents as well. And the librarians are trained by the USPTO to help you out to look for these things. We have very in-depth knowledge from our librarians at these locations, and so they're able to help you. Additionally, we have, as I mentioned earlier, some events virtually that will be going on. I think our search presentation is August 14th or August 17th. I think it's the second Friday in August. So if you're interested in doing that, you can follow up on our Path to a Patent series. Like I said, uspto.gov/Denver, and go to our events, and you can kind of go there. I think we had one more question.
Yeah, so there's patent filing fees, costs associated with the filing of an application, more or less. We have those at the end of the slide, and we'll talk about those patent filing costs. One additional thing about the searching, yes, it's a good idea to search before you file and before you begin really making and using your product. However, one of the fees that you do pay to the patent office is a search fee. And that's part of the examiner's job, is to go out and search the invention. So kind of if we're on a shoestring budget, a lot of times we'll just file an application and see what the Patent and Trademark Office comes up with their search. So anyway, we've got maybe 10 minutes left here. So let's kind of whip through the end of these here. So why invention matters. Again, it promotes public knowledge, innovation. It can help companies grow, protect their goods and services with at least a little bit of certainty that they're able to prevent others from doing it. Also creates new industries and new great things for the public. So let's go to the next slide. So the next 2 slides, patent eligibility, is, the 35 USC 101 defines what's patentable eligible subject matter. And over the last 10 years, we've been in a great state of flux due to the Supreme Court dipping their oar into patent law again to change the definition of what's patent eligible subject matter. On the left, these things can be patented. On the right, we can't have a patent on these. However, there's this hybrid, where I call it a hybrid, between the two, where a process uses a law of nature and applies it in a meaningful way, or an abstract phenomenon, physical phenomena, abstract idea in a process to actually create something and apply that actual law of nature or physical phenomena to be patent eligible. So really the types of things that can be patented are processes, machines, articles of manufacture, compositions of matter, and any improvement of that. The fifth line here is ornamental design. That's a design patent. The last line is asexually reproduced plant varieties and flowers. Those are plant patents. We're not going to talk about them so much. So search, we talked about search quite a bit already. You search US foreign printed publications, the internet, and and you can't search everything, unfortunately. There's sure enough maybe some master's thesis on the shelf of this Basel, Switzerland's university's shelf that you just don't know about that could render your application dead in the water. Again, the types of patents, utility patents cover all of those things we talked about: process, machine, improvements. Design are the ornamental, non-functional things, way things look, the appearance of them. Plant patents, again, are directed to flowers and modifications, genetic modifications thereof. Next, so now on the utility, on the first category back that we talked about, utility patents, we have a first stage where we can file what's called a provisional utility patent application. And typically these are less expensive, less in-depth. They're not examined, but it puts your foot in the door for getting what we call a priority date to say, hey, I came up with this invention. I'm planning on doing something with this application. I know I have to file a full non-provisional utility application within a year. And the non-provisional utility application on the right has to meet all the statutory requirements for what a patent application is. It's significant, well, can be significantly more expensive, and that's what's moves forward in the Patent and Trademark Office and is picked up by an examiner and fully examined. Let's go to fees. There's three, so on the left-hand side are all of the fees that the USPTO collects from an applicant. We've got a filing fee, a search fee, an examination fee, for a total of about $1,800 with an issue fee. Across the top, we have three categories of what fees are paid. And we have large entity is a company or an employer with 500 or more employees. Small entity is less than 500 employees. And then we get to micro entity, and this is a somewhat new creature, which a micro entity is a small entity, but also someone that could be an individual that makes less than about $150,000 a year, has less than 5 applications on file, and it's the way for the USPTO to reduce the filing fees and help out the small guy, which I think is great. However, it helps out all small guys, including all small guys around the world. And David, I wonder if there's a way we can just make that US individuals or US companies and take small entity fees from everyone else around the world.
That'd be great, but I don't control that. That's above my pay grade.
All right. All right. That's it. I'm done. If anyone would like to email me and talk to me about any of this, I'm more than happy. You can find my email on my contact slide on the homepage. Go ahead, David.
Sure. Additionally, I think the question earlier was about provisional fees as well. The same breakdown of provisional fees is $280, $140, and $70. So if you're trying to get your foot in the door, just as a placeholder with a provisional application, and you fit the requirement for microentity status, then it'll cost you as little as $70. So you have this great idea and you haven't found anyone else that's done it, then that's one of those things that might be beneficial for you to do, and it would cost you just $70 to do. Some of our resources in the next 5 minutes that we have left, we have a bunch of stuff on our webpage. It's a government website, so the good thing is everything's on there. The bad thing is everything is on there. And so the uspto.gov/startups allows you to kind of get a little bit of background information, a little bit of what we've gone through in terms of this presentation. I know that we can't really cover 230 years of IP law in a matter of an hour, but if you have questions, then you reach out to Ryan. As I mentioned earlier, the PTRC, these are all the ones that are in our state currently, and then you can see the ones that are in the surrounding or across the whole country. We have them everywhere to kind of provide support as much as possible to all citizens out there that need the help to kind of search for things and get questions answered. And as I mentioned, Mesa County Libraries has one of our PTRCs, and I think they have 2 search terminals there possibly. I know for at least 1, but possibly 2 there that can help you. So not sure if the library is open. Denver Public Library had been closed for a while. I'm not sure if they're open either. And whenever our office reopens, then you'd be able to come in and do the search as well. Pro Se Assistance Program. Pro Se applications are applications that you file on your own. There's help if you want to kind of reach out and get help from the people that are doing this day in and day out. We have a specific group that examines pro se applications, which means they work with independent inventors for every application they work on. Usually we work in specific technology areas. I did cryptography for 11 years. And so these examiners are more generalists. They help just all the inventors that are filing on their own behalf there. But you can get information and get help from them there. This is a big major thing, the Pro Bono Assistance Program. Pro Bono work is free work, essentially. It's free legal work. While they help you prepare your application to file with our office, they take care of all the attorney's fees. And that's, to a lot of people, that's going to be the hardest part, is funding the amount of money to hire an attorney. The attorneys also getting paid, that significant amount because they know what they're doing. As I mentioned earlier, they are the people that you need to go to ask the questions. But this MICASA Resource Center offers ProboPat, which covers those states there. Jennifer Rothschild is one of our good friends for the office in Denver, and she's helped a ton of people start their process in terms of filing the patent applications. It used to be completely free. Now they have a $50 application fee. As long as you meet all the requirements, the $50 application fee is kind of just to show that you are serious, because they were getting inundated with applications from all sorts of people, and it was taking up a lot of attorneys' times that was being volunteered. Additional resources on our website. We have a law school clinic in Boulder at CU there. And then if you don't know what you need in terms of intellectual property, you can go to ipassessment.uspto.gov as well. There's Ryan's information. Again, I will, if you still have questions after this, then feel free to email rockymountain@uspto.gov for the government side of things. You can find Ryan's information here. And as I mentioned earlier, there's a ton of events that we have coming up on our website, on our Denver website at the uspto.gov/Denver. Path to a Patent starts this Friday. If you're more interested about trying to obtain a patent, then we kind of cover the IP basics part of this as we had gone over today, but start focusing more in depth of what the patent process looks like, how to write patent applications, all the ins and outs of that, the searching, and then even up to filing. So you can ask all the experts in terms of all those questions coming up. So you can check out all our information on our website. And if you need to reach us, here's the information again.